If it pleases the court, my name is Rigby, R-I-G-B-Y, initial P, and I appear with my learned junior, Maytom, M-A-Y-T-O-M, initial K for the defendant, Cafe Urban Eats, also known as Q. Your Honour, this case revolves around the question of duty of care, and precisely what standard duty of care is owed by our client to the plaintiff. We will not argue that our client did not owe a duty of care to the plaintiff. This is simply not true, but we will argue that our client maintained the required duty of care expected of him as the occupier of the land, which is Q. Your Honour, as with all negligence cases, the plaintiff must prove that my client owed them a duty of care, the scope of that duty, that my client breached that duty, and finally, that due to my client's actions, the plaintiff suffered some form of real damage or loss. As such, Your Honour, the defence plans to present 4 submissions to the court. These are that no breach of duty occurred, and as such, the entire matter should be dismissed by the court. This will be followed by 3 alternate submissions in the event the court finds against us in this regard. These alternate submissions are: the defendant made every effort to minimise possible harm to the plaintiff by the assaulting party, the defendant did not breach its duty of care by failing to provide a security guard, and the harm suffered by the plaintiff was not caused by the defendant. I'll be dealing with the first submission and the first alternate submission. My learned junior will present the remaining 2 alternate submissions. As such, Your Honour, I shall move on to our first submission. The finding that we invite the court to make is that our client met their duty of care requirements. Your Honour, Q is a small cafe operation. As a retail type operation, the cafe is required to provide a duty of care commensurate with Section 9 of the Civil Liability Act of Queensland. This Act states, at paragraph 1, a person does not breach a duty to take precautions against a risk of harm unless the risk was foreseeable, that is, it is a risk of which the person knew or ought reasonably to have known, and the risk was not insignificant, and, in the circumstances, a reasonable person in the position of the person would have taken precautions. The case Australian Safeway Stores and Zaluna, a 1987 case on appeal in the High Court, determined special and concurrent duties. Their Honours, Justices Mason, Wilson, Dean and Dawson, in their decision on this case, stated at paragraph 10 that an inviter's obligation with respect to dangers on his premises should be measured by the flexible standard of reasonable care. Your Honour, further to this requirement for reasonable care, it is noted that dependent on a proprietor's business, special duties may be imposed by legislation. In this case, Your Honour, noting that the perpetrators of the violent assault were intoxicated, we draw the Court's attention to the Liquor Act of Queensland, which states, at Section 3, the main purpose of this Act are to regulate the liquor industry in areas in the vicinity of licensed premises in a way compatible with minimising harm and the potential for harm from alcohol abuse and misuse and associated violence. The definition of vicinity is not defined in the definitions found in Section 4 of this Act. It is assessed that vicinity be the immediate surrounds of a licensed premises or the area under which it could be expected that the licensed premises maintain control. In the case of TAB Limited and Atlas, a 2004 case in the New South Wales Court of Appeal, the argument by the appellants that the TAB did not itself sell liquor did not provide a determination, either way, that the relevant Liquor Act should, or perhaps should not, be applied. It is such that we argue that the Liquor Act of Queensland therefore has no relevance on this case. Your Honour, we would also draw the Court's attention to the case of Modbury Triangle Shopping Centre Proprietary Limited and Ansell, a case from 2000 heard in the High Court. In this well-documented case, the plaintiff was assaulted in the car park of the shopping centre. The determination in that case can be summarised by His Honour, Chief Justice Gleeson, who states, at 36, the appellant is entitled to succeed upon the ground that its duty as an occupier of land did not extend to taking reasonable care to prevent physical injury to the first respondent resulting from the criminal behaviour of third parties on its land. Your Honour, as you can see, our client met their duty of care obligation to provide a reasonably safe premises to the plaintiff. Our client's duty of care does not extend to criminal injuries caused by third parties outside of the premises, and on these grounds we request you find in favour of our client. Now, Your Honour, if it pleases the Court, I'll proceed with the first alternate submission, that our client made every effort to minimise possible harm to the plaintiff by the assaulting party. Your Honour, as has been stated in the facts, our client did remove the intoxicated third party from Q. At that time, our client believed he had done all that is necessary to remove any risk of harm, and in reference again to Modbury Triangle Shopping Centre Proprietary Limited and Ansell, the Court held that the duty of an occupier does not generally extend to taking reasonable care to prevent physical injury to a person resulting from the criminal behaviour of third parties on their land. Further, Your Honour, noting our client had removed the perpetrators of the assault and witnessed them depart, our client did not foresee the situation where they would return to commit a criminal wrong, foreseeability being a requirement for a breach of duty of care per Section 9 of the Civil Liability Act of Queensland. Additionally, Your Honour, the duty required by the defendant is reasonable care only. Per the case of Rosenberg and Percival, a 2001 High Court case, perfection or the use of increased knowledge or experience embraced in hindsight after the event form no part of the components of what is reasonable in all the circumstances. Therefore, Your Honour, on the evidence of the first alternate submission, we request a finding in favour of our clients. Your Honour, if it pleases the Court, I shall now yield to my junior, Miss Maton, who will outline our final two alternate submissions if the Court finds against us in regard to our primary and our first alternate submission.